I'd like to introduce Peter Kosmic of Kosmic Law Offices. Peter is our attorney for tonight, and he'll be speaking with you and giving you some really good information, be able to answer some of those questions. Peter, there you go.
I'd like to thank you folks for coming out today. Before we get started, I just want to read a quick disclaimer to you. Legal information is not the same as legal advice, which is the application of law to an individual's specific circumstances. The general information presented during this public service event is not intended to be construed as legal advice, nor should it be used as such by any person attending this event. Any legal questions you may have regarding the content of this presentation or your legal rights should be addressed to a licensed Ohio attorney. At the end of this event, we will have a question and answer session, and you'll all have an opportunity to ask general questions. I would ask that if you have a question that's specific to your own case, that you see me afterwards, so that we could talk privately. Otherwise, you'll have a chance to ask some questions to me at the end. More than 6 million borrowers are delinquent 30 days or more. Despite a seasonal slowdown in overall foreclosure activity and a process still bogged down and backed up by robo-signing process scandal, the U.S. real estate market is about to be hit by another surge of bank repossession. Nearly 1/4 of all mortgaged homes are underwater. That is where the outstanding loan balance exceeds the market value. So for example, if you have a loan that's worth $150,000 and the house itself is only worth $130,000, then you're considered to be underwater. Are you one of the millions of people facing foreclosure due to job loss, sudden illness, divorce, or excessive debt that may have prevented you from making your mortgage payments? Well, you're not alone. Currently, some 14.7 million homeowners owe $700 billion or more on their mortgages than their homes are worth. Nearly 1/3 of all Ohio homes are underwater, leaving homeowners owing more than their house is worth. Ohio ranks 5th nationally in the number of homes underwater. What is foreclosure? Foreclosure is a legal action to force the sale of a home caused by failure to make payments. In other words, the lender tries to repossess your home. If you're a homeowner who is currently facing foreclosure, or if you've already been served foreclosure paperwork, important legal rights are at stake. Whenever a court serves a complaint upon you, you have a limited time to which to file an answer. If you do not file an answer in that time period, the bank can get a default judgment and you can lose automatically on a procedural issue. So that's why you can't sit on these things. You have to act quickly whenever you receive any kind of information related to foreclosure. There are different phases of foreclosure in Ohio. Typically, the homeowner will receive a 30-day late notice. This is when the lender advises that we did not receive your payment. Next, you'll receive a 60-day late notice where the lender is going to again advise that they did not receive your payment, and they'll typically threaten foreclosure if you fail to pay. 90 days into the process, they're going to send you a notice of default, advising that they did not receive payment and that the file has been forwarded to an attorney to initiate foreclosure within 30 days. This is also called a notice of acceleration, and typically they'll ask you to pay the full amount of the home that you owe. About 4 to 8 months into the process, a foreclosure actually gets initiated typically when the lender files a complaint. This complaint is always filed in the county where the property is located. Once the complaint is filed, you have 28 days to file your answer. So the complaint will get filed. The sheriff will come out to your home with a summons and a copy of the complaint. He'll serve it to you personally. They can also serve it to you via certified mail. So if you sign for something and you open it up and it's a copy of the complaint, you've been served. You have 28 days from the date you actually are served to file your answer. You can either choose to respond or not to respond. If you respond to the complaint, then the lender has to actually prove their case in court. You're then entitled to question whether or not the lender even has a right to foreclose on your home. If the homeowner does not respond, then the lender is going to get awarded the default judgment I mentioned earlier. Basically, that means you automatically lose. The lender then is going to file a precipice with the clerk who will deliver it to the sheriff. Within 3 months, there's an appraisal, advertising, and a sell date gets set for the home. The home gets sold to the highest bidder. It must sell for at least 2/3 of the appraisal value. Once the sale takes place, a confirmation of the sale is filed, sheriff's deed is issued, and then you'll typically have about 7 to 14 days to move out of your home. Many people may feel, well, that's the perfect remedy for me. I want out of this home. I can't make the payments. That's what I want. Just let me get out of the home. So why fight? Well, the problem is, if your home sells for less than what you owe, then they may be awarded what's called a deficiency judgment. So if your home is worth, say your loan is $150,000 and it only sells for $120,000, that other $30,000 you're responsible for, and they can come after you. They can garnish your wages. They can attack your credit report. They can do a number of things to try to collect that $30,000. So just because you don't have the home anymore doesn't mean you're out of the frying pan, so to speak. You do have options when you're facing foreclosure, such as repayment or reinstatement, forbearance, selling the property, a deed in lieu, short sale, bankruptcy. There are federal programs that offer help, loan modification, or you can fight your foreclosure. I'm going to talk about each of these options in a little more detail. Repayment or reinstatement is when you make a lump sum payment or you receive a fixed amount of time to become current with your payments. The challenges that people typically face are, number one, financial circumstances will typically prevent this from being a realistic option. If people had that kind of money stashed away, they probably wouldn't be in foreclosure. There's usually a limited time to act to get this option, and there will be penalties such as late fees and attorney's fees that you're going to have to pay as well. Forbearance is a temporary agreement with the lender that allows delayed payments for a limited period of time. To get a forbearance, homeowners typically must be able to prove that they'll have the ability to acquire the funds, such as a tax refund or a bonus within a specific time frame. Routine payment schedules will restart after the temporary period, and the skip payments get added to the loan balance. Selling the property on the open market is always an option. The problem is the current Ohio real estate market conditions are poor. There's a large inventory of homes for sale, so it's a buyer's market. Buyer financing is very limited, and most Ohio homes are upside down in equity. So it's going to be difficult to sell your property without taking a loss in this environment. A deed in lieu is when the homeowner voluntarily conveys title to the property to the lender. Now, if you're negotiating with the bank to try to get a deed in lieu so you can leave the home and give it up, you have to make sure you get in writing that there's not going to be a deficiency judgment, because with a deed in lieu, you can face the same deficiency judgment as if they sell your home in a sheriff's sale. In addition to facing the challenge of a deficiency judgment, there could be credit damage and potential tax consequences as well. A short sale is when the lender agrees to accept less than what is owed on the property to satisfy the lien. The potential challenges you would face are lack of qualified buyers. Primary reason these don't go through are the lenders are unresponsive. It's estimated that only 10% of attempted short sales actually get approved. A short sale can lead to credit damage, deficiency judgments, or potential tax consequences. And you saw the video about all the robo-signing and other fraud that's happening in the paperwork. The title companies are aware of this as well, so they may not insure the sale. Usually the only person that benefits is the buyer themselves. A whopping 46% of homes sold in November were either short sale or REOs, as the home repossessed by lenders are called. Bankruptcy isn't always an option. We call this the nuclear option because it's really your last resort. Bankruptcy is a process in which debtor is given a fresh start and relief from the debt. You can file a Chapter 13 or a Chapter 7, and Chapter 13, the home gets repossessed, and in Chapter 7, many of your assets, including the home, could be lost to satisfy creditors, and this stays on your credit report for anywhere from 7 to 10 years. There are federal programs available that can help you if you're facing foreclosure. The first one is called HAMP, or the Home Affordable Modification Program. This is a government-sponsored refinancing program that was designed to help struggling homeowners avoid foreclosure by modifying loans to a level that is affordable. In order to qualify for HAMP, you must meet very specific criteria. For example, you must be delinquent on your mortgage or face imminent risk of default. You actually have to occupy the property as your primary residence. Your loan balance cannot exceed $729,750. No principal reduction is possible. When I say principal reduction, again, if your home loan is for $150,000, but your home is only worth $130,000, if they reduce your principal down to $130,000 so that the value of your home is now equal to the amount you owe on your loan, you could then sell your home without taking a loss. This is the option that a lot of people in the government have been pushing the banks to do. Principal reductions, it seems like the most obvious fix to the problem, but banks are not willing to do that. And so instead they want to do loan modifications and change your interest rates and extend the loan out for longer periods of time. And so, they're not willing to take a haircut, so to speak, and take a loss. We feel that HAMP has pretty much been a failure. It was expected to help 3 to 4 million people, but to date it's only helped about 300,000 people. The next government program is called HAFA, or the Home Affordable Foreclosures Alternative Program. This is an option for those who are not able to keep their homes through HAMP. It provides incentives in connection with a short sale or deed in lieu of foreclosure. In order to qualify for HAFA, you must first go through HAMP. The loan modification didn't allow you to keep your home, and so basically they pay you $3,000 to leave your home and start over, but it guarantees that no deficiency judgment follows you. Foreclosure relief, don't hold your breath. Throughout the foreclosure crisis, Washington has done little to help people hang on to their homes. All those programs that were supposed to, HAMP, HARP, Hope for Homeowners, have mostly failed, according to the New York Times. The number one reason people typically come to these seminars is to learn about loan modification. This is when the lender reduces the interest rate or changes the terms of the loan so they are more favorable to the homeowner. The potential challenges are, number one, lenders may be unresponsive to homeowners. How many of you have been talking to your banks and find that you're getting the runaround over and over and over again? Every time I come to one of these events, every hand flies up. The banks are doing this to you intentionally, and we're going to find out why later on. The other challenges you face with loan modification are new terms may be unrealistic for current financial status. If they offer you a home loan modification that changes your payment by $30 a month, is it really going to save your home? Probably not. I've actually heard stories where they want to modify your loan so that your payment goes up, believe it or not. And so it doesn't always work even if they agree to do this for you. In order to get a loan modification, the homeowner's financial status must be stable, and again, it's difficult to obtain a principal reduction. 3 years after the foreclosure crisis began, the process to apply for a loan modification remains a bureaucratic nightmare. Banks are totally and intentionally dysfunctional. The reason they get away with this are they are dealing with customers who are not educated in the way things are supposed to work. They just keep browbeating people until they give up and go away. Complaints against Bank of America accuse the company of failing to provide answers or repeatedly losing documents, of lying about sending letters that were never sent, and of proceeding with foreclosures while customers are still trying to get modifications. According to the U.S. Government Office of Comptroller of the Currency Reports, more than half of all loan modifications created have already redefaulted by becoming more than 60 days past due by 9 months after the original modification. As foreclosures have mounted in recent years, regulators have been trying to get lenders to reduce the principal on home loans for delinquent borrowers. But banks have preferred to cut interest rates or extend payment periods when they modify loans. Folks, you have to be aware of foreclosure scams and schemes. There are companies known as foreclosure rescue companies. They have become widespread with promises to help homeowners avoid losing their home. Unfortunately, many of these companies use questionable, sometimes illegal tactics. The result is often lost money, ruined credit, loss of any equity in the house, and sometimes even losing the house itself. Not too long ago, I spoke to a woman who paid $1,000 to a man who came making a series of promises to her. The man skipped town and has never been seen again, and she lost that money and she's never going to get it back. How do you know if you're dealing with one of these foreclosure rescue companies? Number one, listen to what they're promising you. There's no such thing as a guaranteed outcome when you're fighting your foreclosure. You don't know what your paperwork is going to have inside that you could use as leverage. You don't know what kind of judge you're going to get. the one legal issue can be determined by Judge A in favor of the homeowner, while the very same legal issue argued in another court before another judge can be found in favor of the bank. That's the way the law always is. There's a big gray area of ambiguity, and so it's impossible for anyone to guarantee an outcome. And if you hear someone guarantee an outcome to you, you should run the other way. Number 2, do your research. Go online. For example, NACA, Neighborhood Assistance Corporation of America, is one of these foreclosure rescue companies. If you just Google them online, you'll see a number of websites where people talk about their experiences. For example, complaintsboard.com. I was at the Chicago event yesterday. Do not waste your time. I wish I had done my homework on the complaints board before I went. So do your research, listen to what they're promising you, and you'll be fine. Predatory lending. When a lender or mortgage broker engages in deception or fraud, or manipulates the borrower through aggressive sales tactics, or takes unfair advantage of a borrower's lack of understanding of loan terms, you could be the victim of predatory lending. Predatory lending has been rampant over the last 7 to 8 years. The Wall Street Journal reported in 2006 that 61% of all borrowers receiving subprime loans had credit scores high enough to qualify for prime conventional loans. Bank of America / Countrywide Funding agreed to pay $335 million to settle allegations it discriminated against minority buyers by steering them towards dangerous subprime loans. Fighting foreclosure is the only way to make sure that consumers, especially those who are tricked into loans they couldn't afford, are treated fairly, because the banks aren't doing it on their own, and that's according to the American Association for Justice as far back as December of 2008. Listen to what the bank is arguing. It is unfair to reward homeowners who are delinquent or underwater but cannot point to specific errors in their case. Poor banks, right? Well, this is why we recommend to people that you get your documents looked at by a professional, because you can often find leverage inside the paperwork, violations, and whatnot that you can use to help negotiate. Astonishing numbers of those cases are riddled with paperwork errors, if not outright fraud. But it only comes to light if the borrower has the money and stomach to hire a lawyer and take it to court. In the rare event that a homeowner puts up a fight, the outcome is seldom dramatic. The case drags on for months and years in Dickensian tangles of legal documents and court hearings. In some jurisdictions, more than 90% of homeowners facing mortgage foreclosures have no legal representation. In Cook County, tens of thousands of foreclosures are processed annually, putting the bewildered people up against bank attorneys or mortgage servicers. The fraud perpetuated on some of these people by some of these companies invoking the power of the state, from the courthouse to the sheriffs, goes largely unchallenged. No wonder the banks feel no need to engage in serious negotiation to ward off evictions. A large number of people, when they're served a complaint, simply don't answer, and they go into default judgment. They lose automatically. Their homes get sold. Because not enough people fight back, the banks continue to do this. To this day, I'm still finding robo-signers in the documents. I'm still finding invalid assignments. The other day, I had a case dismissed because they actually assigned the loan to an entity that no longer exists, believe it or not. And so it goes on and on and on as we sit here today. Questionable fees. The New York Times reported an analysis of foreclosures found that questionable fees had been added to half of all the loans examined. How do you know if your loan has lender violations? 8 out of 10 home loans have lender violations. That means 80% of the people sitting here today have actual loan violations in your paperwork that you could potentially use as leverage. Some violations can give you leverage with your lender in negotiating a loan modification. Some violations could possibly enable you to sue your lender for damages. Some extreme violations could actually allow your loan to be rescinded. There are regulations that were designed to protect homeowners. The Truth in Lending Act, Home Ownership and Equity Protection Act, the Real Estate Settlement Procedures Act, the Fair Debt Collection Practices Act are some of those laws. What is mortgage securitization? 30 years ago, if you got a mortgage from a bank, it was very likely that the bank would keep the loan on its balance sheet until the loan was repaid. That's not true anymore. Most of your loans get sold on Wall Street. That process is called securitization. In many cases, your loans were sold over and over again without your knowledge. The New York Times reported that some loans were traded as many as 600 times while the banks continue to profit. The University of Iowa found that 40% of banks foreclosing on borrowers could not prove they actually own the loan. In order to foreclose on your home, you have to be the person who actually owns the loan. And every time a loan gets transferred from entity 1 to entity 2, there is paperwork that must be filled out and processed and filed and recorded, etc. If they fail to do that, they may not be able to prove standing in court. But because, again, so many of these foreclosures go unchallenged, you know, they foreclose on 10 homes, maybe one person fights, so 9 people, even though they can't even prove that they have standing, you know, they're finding themselves facing a sheriff's sale. Lack of proof can prevent foreclosure. A federal judge in Cleveland, Ohio, dismissed 14 foreclosure cases because the trustee was unable to prove ownership of the notes. Because of lenders' bundling and reselling of mortgages, notes are often lost, misplaced, or corrupted. As a result, many lenders can't prove that they are owed payments and entitled to foreclose. Delinquent borrowers facing foreclosure are learning that they can stay in their homes for years as long as they are willing to put up a fight. Among the tactics, challenging the bank's actions, waiting to file paperwork right up until the deadline, requesting the lender dig up original paperwork, or in some extreme cases, declaring bankruptcy. Time is on your side when you fight a foreclosure. You're the defendant. The plaintiff has to prove their case. And so the longer you drag these cases on, often that very act of simply dragging the case on gets you the leverage you need. Some attorneys are hired based upon how quickly they can process a foreclosure through the court system. Well, when an attorney shows up and files an answer or files a motion to dismiss, it severely slows that process down. And so if you're dealing with one of these plaintiffs' firms that is rated according to their speed, you're going to get leverage just by simply hiring an attorney. Likewise, some attorneys get paid a flat rate to prosecute these cases. The more work they have to do, the less time or the less money they're going to make per hour. And so you can see if you're litigating one case for 6 years and they've already used up all the money that they've been paid, they're going to want out of the case. And so you can get leverage just by simply working the legal system. Revelations that lenders use so-called robo-signers who sign foreclosure orders but did not actually read them could give borrowers leverage to seek loan modifications rather than lose their homes. Allegations of possible mortgage fraud against financial giants GMAC, JP Morgan Chase, and Bank of America read like a corporate thriller. Forged documents, fake social security numbers, phantom titles, disappearing paper trails, robo-signers, and mortgages sliced and diced so many times that nobody really knows who owns them. You've probably heard me say GMAC or JP Morgan Chase a lot, or Bank of America. It's not just these banks that are committing these violations. Almost all the banks are guilty of the same thing. All 50 state attorney generals, as well as a host of federal agencies, are pushing for a settlement over investigations into foreclosure abuses by major mortgage services that could cost the industry $20 billion or more. In numerous opinions, judges have accused lawyers of processing shoddy or even fabricated paperwork in foreclosure actions when representing the banks. Again, these lawyers that these banks hire, they're not going to look and see if the assignment's proper unless they're challenged, because they know that 9 out of 10 of these are going to go through because nobody's going to fight. Former Ohio Attorney General Richard Cordray sued GMAC Mortgage, alleging the company filed false documents in hundreds of Ohio foreclosure cases. Cordray stressed that the other big banks may be guilty of the same practice. Why is having the original promissory note important in a foreclosure action? The original promissory note is a live negotiable instrument. It's just like a cashier's check from the bank. It's the IOU that the borrower actually signs. Lenders may try to foreclose on your home with just a copy of the promissory note instead of the original. If you took a copy of a cashier's check to a bank and tried to cash it, I promise you, you're not going to walk away with any money. The banks, however, repeatedly try to do the very same thing with these promissory notes, primarily, again, because 9 out of 10 people aren't even fighting back. Lenders may try to foreclose with a copy, but if the lawsuit or foreclosure isn't challenged, the lenders are automatically going to win by default. The assignment of a mortgage from one holder to another is an exacting process that requires proper assignment forms, And in many cases, improper and fraudulent assignments of mortgages have been discovered. A lender must prove that they have a right to foreclose, and this is called standing, and can be proven through proper foreclosure paperwork or possession of your original note. There are some pre-foreclosure strategies. What can an attorney do before the foreclosure is filed? A qualified written request, or what's called a QWR, should be sent to your lender or servicer requesting specific information regarding your loan. Responses from your lender should be carefully reviewed for lender violations. Counsel should handle filing all necessary paperwork and all negotiations regarding loan modification, or counsel should negotiate a short sale or deed in lieu. An extensive foreclosure review of your documents provides useful information for a foreclosure defense case. Fraud is regularly discovered, and you may discover that the lender has no right to foreclose on your home. Let's say you've been served. What do you do next? If the foreclosure lawsuit's already been filed against you and you've not retained an attorney, do so immediately. The attorney should perform a forensic audit of your loan to look for violations. The attorney should also conduct an intensive foreclosure document review to look for errors and/or violations. They should perform what's called a securitization audit to determine who actually owns your loan. Then the attorney should aggressively litigate against your lender to achieve the best possible outcome for your case. I can't stress this enough. There are no guarantees of a specific outcome when you fight back on your foreclosure. What I can guarantee is if you do not fight at all, the bank is going to win by default judgment, and you're going to be out of your home. Do you have time to act? Time is very limited with respect to foreclosure proceedings. You need to examine the best options available for your circumstances and take action to protect your family's well-being. And that's where this presentation ends.